Monsieur le Président, dear President, dear colleagues, ladies and gentlemen, I'm honored and pleased to welcome you in Rome, and the Italian Bar Council brings you the best wishes for a good work and the best greetings of the Italian lawyers who are extremely interested in the studies, researches, and determinations of the Ccbe1. I'm glad to see many friends and have been admitted at this seminar eminent scholars who yesterday discussed with us the problems of the comparison between the Italian legal model and legal models of Southern America. We asked also to the stakeholders, the Italian stakeholders at the CFR.net to come and just to listen to the discussion. And I'm glad to tell you that the problems concerning the subject that today we will treat are well known by the Italian Bar Council and Italian lawyers. Just because since 1999 the Italian Bar Council organizes each year seminars and conferences for the examination and discussion of the problems relating to European private law. This initiative has been promoted amongst the cultural activities of the Italian Bar Council, also with the aim to participate to the construction process of European law in order to facilitate the creation of the internal market through the application of uniform rules. European lawyers, whatever countries they belong, must be able to offer the same remedies to their clients. The Italian Bar Council has been in contact with various study centers researching European private law, mainly with the Lando Bill Commission, and I'm honored to guest here Professor Bill, and with the group directed by Christian von Bahr. You know that in Italy also there is a group, Professor Gandolfi group situated in Pavia, another group in Trento, which is studying the common core of legal systems. European private law, in particular contract law, are studied also in many universities in Italy, and great interest in this subject have arisen in the bars. For us, this meeting is not only a work session, but a very important occasion for our country. The Italian Bar Council wanted also to witness our deep interest in cooperate with the Ccbe1 and wanted to show concrete solidarity in order to contribute to a discussion and evaluation of problems which had already dealt with the Ccbe1, and we have invited at this meeting only the Italian jurists who are involved in the program, but many would like to come, but in any case we will do another meeting if you agree for the public. Today we do not want only to limit ourselves to, so to say, wait and see approach in connection with important subjects under discussion, and we suggest that if the Ccbe1 cannot reach a unitary position, we can at least make step-by-step decisions, and so to go on with our work and follow the work made by the researchers and by the community, European community. This because the construction of European private law cannot be delegated only to European or national legislators, to universities and to the judiciary. We lawyers, because we practice law, must give our contribution. And with this wish, I think that we will do a very good job. And for this reason, I wish to you all, besides my thanks for having come here, the best result to reach in these 2 days. Thank you very much.
Hello, dear gentlemen, dear ladies. I'm happy to welcome you to this conference, which has been organized by the Ccbe in cooperation with the Italian Bar Council. And I would like to express my deep thank you for the Guido Alpa and the Italian Bar Council to give us the opportunity to have this conference in Rome, in this lovely premises. I'm speaking on behalf of Manuel Cavaliero Brandão, the president of the Ccbe, who unfortunately cannot participate in the meeting today. He has been already at the airport, but doctors advise him to not take the flight and rather return for reasons of health. So I would like to carry forward his message to you that the subject of European contract law is very dear to his heart, and he wishes us very good discussions and very much hope that this conference will have a great success. The subject of European contract law is dear to his heart because he sees a great importance of this theme for the legal profession at European level, and also at national level every lawyer is concerned with the application of one of the core fields of legal activity, contract law. So in an overarching approach at European level, lawyers should get involved and should formulate an opinion on this. This is the aim of the conference, to see what kind of views, given the very different legal traditions we have in Europe, could be found among lawyers concerning the subjects. The European institutions are striving hard to deal with this subject matter, and it's not easy. But it would be good if the lawyers could find a unitarian position and support the process which is taking place within the institutions. And I underline everything Guido Alpa said, that we should put every effort into this conference to have a fruitful discussion and hopefully a good position in the end. Thank you.
Monsieur le Président, Mesdames, Messieurs, j'étais comme vous il y a encore quelques minutes, espérant tranquillement passer mon après-midi activement pour écouter, mais ne m'impliquant nullement. Grâce à l'obligeance du Président Alpa, me voici à la tribune, chargé de faire le travail que devait faire le Président Brandão, dont nous regrettons bien sûr l'absence, c'est-à-dire tenter de passer la parole. Tâche difficile. Et puis d'être le modérateur, c'est-à-dire président de séance, pour respecter les horaires. Vous noterez déjà que nous respectons parfaitement le premier horaire qui était prévu, puisqu'il est 15 h et nous pouvons débuter concrètement les débats. Et concrètement, cela veut dire passer la parole au député Lenné, qui va traiter des développements actuels en matière de droit européen des contrats et surtout donner le point de vue du Parlement européen, puisque c'était la première intervention prévue. Donc, je pense que tout se passera très bien. Il a une demi-heure pour exposer le point de vue du Parlement, puis ensuite, nous aurons une phase de questions-réponses qui, je ne le doute pas, sera passionnante. Je vous passe donc immédiatement la parole.
Thank you very much, dear Chairman. Ladies and gentlemen. First, I would like to thank the Ccbe for this invitation today and for giving me the opportunity to speak to the organization of the most important stakeholders involved in this whole process, because everything what is developed here and what may be later decided by Commission and legislators has to be used by you, by the lawyers within the European Union. You will be the first that will be confronted with the possible legal results of this work, and from that point of view I think it is quite logical that from the point of view of the legislator you should be the most important stakeholder to comment the developments and to define an idea what you think about that and how you can support the process. And I'm very, very happy about this chance to speak to you and about your interest in this file. I know all the time that the Ccbe is, it's quite clear, it's a job, a critical but generally positive supporter of the whole process, and I appreciate this very much. In my short speech that was prepared some weeks before, where we even did not know some actual developments, for example, regarding the structure of competences within the Commission with the beginning of next year, I will only mention those aspects that had been more or less unanimously supported by Parliament in its resolutions in the past. I think if you want to speak about further aspects about that, what might be the further structure of the work of Parliament and Commission on this subject, we can do that later within the discussion, and I can, if I have the opportunity, can give you some additional information if you have questions on that point. Ladies and gentlemen, the project of European contract law has arrived at a turning point. At the time being, it is not clear how the Commission will further approach this major task. However, from my personal point of view, which is shared by the vast majority of the members of Parliament, the development of European contract law is of utmost importance for this election period, despite the reduced media interest and only at first sight political interest in the member states. Therefore, Parliament is fostering the development of European contract law by directly participating in the work that is undertaken. An internal Parliament's working group, supported by a project team within the Parliament, was set up in order to follow the work of the European Commission on this matter. It's under the leadership of the Legal Affairs Committees under my chairmanship as being the rapporteur on this item within the Legal Affairs Committee. The working group has agreed with the European Commission to give each other the kind of a status of an observer so that Parliament's representatives could be present at the workshops of the common frame of reference and Commission representatives on the other side at the working group meetings. This involvement can only be comprehended by examining the wider political context. Any decision on European contract law, whatever the outcome may be, is political and legislative and consequently has to be taken by the legislative authorities, Parliament and Council. Parliament therefore has to give its input at a stage as early as possible. So far, Parliament has expressed its opinion in several resolutions, the most actual ones dating March and September of this year. The tenor of the resolutions and consequently the point of view of Parliament is concentrated around four major items. Namely, the claim for further harmonization of civil law, no limitation of the process on consumer protection, aiming at a possible legal instrument, and finally putting current legislative proposals in the field of contract law on hold in favor of a horizontal approach. This project is not a hobby of academics. As early as 1989, the European Parliament passed a resolution calling for the harmonization of civil law across the European Union on the basis that it was necessary for the proper functioning of the internal market. It is very clear that different national laws pose an obstruction to the international market or can do so. On the one hand, there are trading limitations concerning directly the exchange of goods and services, for example, high legal costs for adjusting standard contracts in order to meet the legal systems in each member state. On the other hand, these different systems confront those who try to solve legal conflicts that arise from cross-border trade. No lawyer or judge can deal in parallel with 26 or in future 28 different civil law regimes, in particular in cases which involve small claims, especially consumer cases. Indeed, it is the variations of different legal systems that impose a major obstacle for cross-border trading in the internal market for everyone. A survey carried out last year showed that business considers this a major factor limiting their commercial activities within the European Union. So it's not only a matter for consumers, as well for businesses. The report also came to the conclusion that the European contract law would foster economic activity of companies despite some remaining obstacles such as linguistic diversity, transport costs, and others. These results are not surprising. The European Parliament has always expressed its view that facilitation of cross-border trade within the internal market can only be achieved by pursuing the project on contract law. The survey furthermore supported this huge project as businesses announced their intention to use the new law once it will be given as an optional model to the market participants. Just to mention some examples for insurers that could be perfect to use this, for the first time we could create something like a common market for insurances. All those big companies that sell their goods directly to the consumer at the end may have big advantages of this. I just mentioned the automobile industry, for example, but in other areas it's probably quite similar. Again, this is one of the demands from Parliament, as it should be left to those who make bargains to decide which law to choose. However, the internal market aspect is not limited to business needs only. The internal market will moreover be complete when consumers can take full advantage of the benefits it offers. Firstly, economic participation of the consumer within the internal market will be facilitated if the consumer can have recourse to a legal regime known throughout the Union. Secondly, and this rather psychological element is not to be underestimated, Parliament has been stressing out that raising public confidence in and thereby further completing the internal market can only be achieved by delivering a higher level of consumer protection. As a result, work on the CFR should not lead to a dilution of the values at heart of the existing consumer protection acquis. This does not imply, though, that the work undertaken should concentrate on consumer protection issues. On the contrary, European Parliament is stressing out that any work on a future European contract law should not be limited to the consumer protection field. The CFR should cover all aspects of civil law. The rationale behind this postulation is obvious. Only on the basis of a broad CFR, all options for further developments in the civil law area will be available in the future if needed. Therefore, members of Parliament's working group agree on a horizontal approach to be taken. We consider it important that contract law should be overhauled generally. The past has shown that regulation by specific sectorial directives may result in incoherence in many areas. You all know the examples. However, future provisions should distinguish, as far as affected interests so require, between legal transactions amongst businesses and consumer, B2C and B2B. Nonetheless, as the CFR has to be a general framework, its basic rules should apply to B2C contracts as well as to B2B contracts. Parliament therefore recommended that the envisaged contract law should not be designed in such a way as to unilaterally favor one restricted group of participants in legal transactions. Furthermore, Parliament's working group is carefully supervising the draft provisions presented with special regard to the freedom of contract. In particular, in the area of B2B transactions, businesses must be able to agree on certain terms individually in order to avoid burdensome and needless restrictions. European Parliament considers it important that a future European contract law could be a binding instrument insofar as it should provide anyone taking part in a legal transaction with an alternative civil law regime. Certainly, this will have to be optional in nature. The parties can agree to fulfill their obligations under European contract law, but also abstain from the new regime and choose a traditional one they are accustomed to. This is a crucial point in Parliament's demands, as we consider the optional model best to meet the needs for cross-border transactions. In so doing, the market will decide if the rules fit its needs, and thereby proving those wrong who claim that a European contract law will lack, due to a misinterpreted free market approach by the European Treaty, any fairness in contracts. The consumer will have to decide if this difference between European contract law and national contract law provisions really exists. Therefore, the Commission is asked by Parliament to continue its work on the CFR on the highest level possible. Indeed, this wide approach can only be justified if the CFR satisfies its expectations. It has to be of the highest quality in order to be the toolbox for further developments. And indeed, one final outcome could be a binding legal device with an opt-in or opt-out possibility. However, at this stage, no one can say what the final outcome will be. At this stage, speculations on the European Civil Code remain speculations, as do considerations for an optional model. All those decisions will not be taken within this legislation period, but by future legislators, in the next or even in the legislation periods after that. But I think what we have to prepare is, we have to prepare the opportunities. So we have to have an instrument which gives them the opportunities to decide what they want to do and what is necessary for the further development within the internal market. Finally, European Parliament considers it's necessary that in the near future no further proposals on contract law issues should be pursued. I heard, for example, that within the Enterprise DG there is a discussion going on reforming the Late Payment Directive. I don't think that this is a good idea to do something like that right now. We should wait for the finalization on the work of the CFR and then for the consultation after that before going on with such kinds of legislation. We are not generally asking for a standstill on legislative proposals. However, all legislative measures which are linked with the CFR should be derived from the new framework. Otherwise, the danger of new legislation differing from the CFR and producing other inconsistencies would be too great. Within Parliament, there have been doubts concerning this claim. However, as the Green Paper on the revision of the consumer acquis will be finally published before the end of this year, and the consultation period will be set, it is unlikely that any precise proposals will be presented before the beginning of 2008. This will be the time when we expect the CFR to be published as well, end of 2007, beginning of 2008. We have been told that the Commission will be in favor of a mixed approach in its Green Paper. Some of you probably have already seen the first draft of the internal document of the Commission. That's exactly what they are proposing there. A horizontal approach will be taken and, where necessary, also a vertical one. However, more importantly, the Commission will decide on how to further approach the European contract law project by mid-November. I hope so. I'm not so sure anymore, because you probably have heard that there will be a change of competences in the Commission, and that the new Bulgarian Commissioner will be in charge of consumer affairs, and it's quite likely that she will take over this file as well. And from that point of view, I personally believe that it is not very likely that we will have a new decision, a new agreement between the commissioners in charge of the Commission until the end of this year. This will probably happen at the beginning of next year. No one, especially I don't think so, that Commissioner Kypriani will make decisions right now, will participate in decisions when he knows that this item will go to someone else within a certain time period. Under the German presidency, there will be a conference held in March in Stuttgart next year. I'm expecting a new impetus from the German government for the project of a European contract law. You know, there was the conference in London and there was the conference in Vienna. The Finnish presidency is not doing very much on this item, to say it quite openly. And the German presidency will really, they are trying to do something on this, and there will be a lot of activities. I, for example, have heard that the Justice Ministry in North Rhine-Westphalia, which is by far the largest land in Germany, will as well have a conference on this issue with practitioners, especially dedicated to practitioners, in April in Münster, inviting all the important stakeholders and the representatives from Parliament, Commission and Council to this meeting as well. And then I heard as well that the German Lawyers Association, DRV, wants probably to make this one of the key items of the Anwaltstag of the General Assembly in May in Mannheim. So there are a lot of things going on in that direction, and I hope that this will give a new impetus and really brings it to a point that shows how important this development is, because I think there will be probably an agreement with all the people here in the room that this will have a strong impact, even if we do not know yet what the final outcome will be, but those works will have a strong impact on the development of civil law within the European Union and within the member states. I have no doubt about that. Whatever the outcome will be, the need for European contract law is apparent. Consumers as well as businesses need a contract law they can choose as a legal basis, in particular for their cross-border transactions. Consequently, European contract law has to be of the highest quality, as only the quality will be an incentive for consumer and businesses to choose the new regime. Finally, this huge project has further implications. It is a novelty that at a stage this early, practitioners and academics gather for such a fruitful exchange of views. This approach could have a model character for future complex projects at European level. You know, we have a big discussion in the European Union on the question of better legislation. And I think that could be, it's not sure that it will be, but it could be one of those examples that show how a better legislative, or what is more right, a pre-legislative process could happen, and how we could introduce ideas of practitioners, experiences of practitioners into a legislative process that could be as well a kind of really business impact assessment. Something like this, and not going any longer along the track of learning by doing in legislation. And from that point of view, I think we more or less within the European Parliament support this project in general, and there is a big support for the activities of the Commission in the direction of the network as well. And what I wish for myself is that the Commission starts to go on with the network next year. And to tell you from my personal point of view, if Commission is not doing this, you know there will be probably a consultation document by the Commission in 2008. Then Parliament has to do this. That means that we have to go on to the end of this legislation period through a process in which we really use the chance to discuss the results of the work with the stakeholders, chapter by chapter, point by point, to get ideas, and then at the end to deliver a position of Parliament at the end of this legislation period that really reflects the positions of the stakeholders, and because you are the most important stakeholders, I hope it will reflect your positions as well. Thank you very much.
Je remercie Monsieur le député. Il nous a montré l'importance de cette réflexion et la détermination du Parlement, et il a évoqué l'impact de ces modifications et de l'ensemble de cette étude. Je suppose qu'il y a déjà des questions qui pourraient être posées à M. Lenné concernant le point de vue du Parlement européen, peut-être également les questions de planning, les délais d'avancement de cette réflexion. Je pense que ça peut être déjà un élément qui pourrait être apporté dans ce débat. Y a-t-il quelqu'un qui veut poser la première question, qui est toujours la plus difficile? Allez, le président Alpa. Ah.
Il y a deux, en fait.
Qui est-ce qui a vu?
Le monsieur en
Ah,
arrière.
allez-y.
And consequent on that, the Commission in particular, but the European institutions in general, will look to formulate a practical CFR, and of course that is the document or the material, whatever it is, which will have effect. Do you see any difficulties, or I think there are undoubtedly difficulties, but how do we balance those difficulties between producing quality on the one hand and working to a very extreme time frame, a constricted time frame on the other? I'd be very interested to hear your views in that regard.
Thank you very much. I think this is indeed a very important question. And I try to answer this on the basis of a wider background, because we probably have to explain, or I probably have to explain, how this whole process started and what was the idea and the result of the exchange of views between the Commission and us in the Legal Affairs Committee, how this whole thing should function. The first problem when this whole project more or less started in the 80s, I think the original ideas are from the 80s, was that we had been quite afraid in the Legal Affairs Committee of the Parliament that if the Commission starts a work like that, they will do it the usual track. And the usual track is that they ask one of the classical consultancy companies in Brussels to solve the problem, like they are normally doing when they make proposals for sectorial directives. And that's exactly what we do not want it. We had a hearing in the Legal Affairs Committee at that time where we invited some people involved in the development of general principles and of European contract law. Professor Gandolfi, for example, was there. We had Professor Lando invited there and some others. And the result of this workshop, hearing is the wrong word for this, this workshop was more or less that we have to force the Commission not to use the usual track, but to improve the quality to use academic instruments. And the next idea was, how can we do this? Then the idea behind that was, okay, we can use the research, the framework research, research framework program. There was no point in the research program for legal research on such a matter. So we managed with the Industrial Affairs Committee that is in charge of the research framework to have a certain line in there, especially for this kind of research. And then it was possible to do something on that point. The result are now the existing 3 different working groups that are doing that work on the basis of the money that is part of the research framework research program. Sorry. And the next problem was when the academic starts. You know, nothing against academics. A lot of academics here, but you know, there is a little bit of danger that if academic starts is at the end, this is systematically beautiful, but not always useful for practitioners. Yeah? It can be. It can be. No, it can be. My experience as being a law student in Germany was that there is no idea so crazy that it could not be supported by a German law professor. But
I'll see you outside office.
Okay, but forget about that. Okay, so the idea was what we probably have to do is we have to compensate this in introducing practitioners into the process. Then the idea of the network was created. And I still think that this idea is in principle a very, very good one. I know that regarding the process, it was not always harmony between the 3 different structures in the network. Practitioners on one side, academics on the other side, and commission. Sometimes there have been difficulties, and one of the resolutions, especially the resolution of spring, is exactly addressing this problem. Not all of them is the fault of the academics. For example, one of the problems that was simply there was the short deadline for reading and for writing comments, 1 month, for example. That was simply not enough. And so this has to be improved. It was improved already. The Commission changed some aspects on that point. But this is all related, as you said, to the question of quality. And at the end you said, is this all enough time? I'm not so sure if this is enough time. But you know the rules of Parkinson. Every job is finished when the time is finished. That's quite clear. And you have to have certain deadlines. And from my point of view, I think one of the deadlines is simply the simple fact that we have to achieve something within this legislation period. And that finished in 2009. The job of this Commission and the job of this Parliament finished in 2009. So there should be a result, and not only a result in the academic world, but a political result at the end of this legislation period. And that makes it quite necessary that there had to be a limitation for the researchers to produce the CFR, and that there has to be a limitation at the end for Parliament, Commission and others to deliver a first commentary, a first result, a political result that has to be at the end of 2009. And what we have to do is we simply have to achieve that with all necessary measures we can guarantee a certain result of quality at the end. And I still think this is possible. As I said, the future structure of work will be the following. There will be the CFR at the end of 2007-2008. Then Parliament, I don't know in which way, but probably in the existing Legal Affairs Committee or in a new special body, we have to see what we can achieve. Parliament will go very, very seriously through this CFR and will write an important report on that point and expressing its opinion. I'm sure that the Commission will, as well as the Council and the national governments, will deliver opinions in that direction. All stakeholders will have the opportunity to say something. So the Ccbe, the national associations of lawyers, of judges, of notaries, everyone who has interest, industry, commerce, consumer, everyone will have the opportunity to deliver its opinion. And then the final outcome is not the CFR. The CFR is an academic work that is more or less the base for the further work. The final outcome, the possible optional instrument that has to be decided in a legislative process at the earliest in the next legislation period, that has to undergo a lot of steps. That starts with the final decisions of the Commission, what they want to do. There will be an impact assessment within the Commission. Then we'll have the first reading in Parliament. Then we will have the decisions that have to be made in Council. There will be a lot of opportunities. And my feeling is that the process at the end will last much longer than 2009. Before something will be finalized, my feeling it will be 2012, 2013, 2014. So there's enough time in further steps to improve it, to have new ideas and to make some things better than they are originally. So I'm not really afraid about the problem that the lack of time can reduce quality. Because we are just in the middle of the whole process and there is still a lot of time, a lot of steps that we have to do before we really have the final result. Okay? Good.
Merci de ces éléments, y compris sur le planning. Il y avait d'autres interventions. J'avais noté une deuxième main qui se levait. Je vous en prie.
Parlo in italiano. Sono un giudice della Cassazione, ho partecipato ai lavori del network degli stakeholders. Volevo porre al deputato Lehne delle questioni che hanno un taglio anche politico, cioè se il Parlamento avrà, diciamo, un ruolo nel prospettare la relazione di questo CFR con la Carta dei diritti fondamentali. La seconda domanda è questa: se nel caso in cui la Commissione abbandonasse questo progetto, ci sono delle possibilità che il Parlamento prenda lui la iniziativa di completare e portare poi a una vera e propria proposta questo risultato del lavoro? E poi volevo sapere se le posizioni che sono state espresse nella relazione sono state discusse a livello politico dei gruppi parlamentari e se c'è, diciamo, una visione condivisa su questo giudizio positivo della unificazione o comunque di una forte armonizzazione orizzontale del diritto contrattuale europeo tra i vari gruppi politici del Parlamento. La ringrazio.
Thank you for these questions. I'll start with the last one because that's the easiest to answer. I think there's a complete agreement between all political groups that we want to go on with this work and that we in principle support this. That does not mean that there is yet an agreement about that, what will be the final outcome. Because I think everyone first wants to see the result and then wants to see the result of the works on the CFR, for example, and then to make a decision about the next steps in the process. That's quite clear. But the idea that this should be aimed or targeted at the end on a legal instrument is common sense within the House. So there is no agreement, no disagreement between the left and the right, or the center, or the leftist, or there's nothing in that direction. So there's a broad support for this subject, no problem. You can see voting on the resolutions. I think we had now 8 or 10 different resolutions since the 80s. all of them had a support of 90% plus X. So that's quite clear. There's no real difference on that point. And those people, the three people that are mostly involved in this, are myself as being the rapporteur in the Legal Affairs Committee, Diane Wallace, British, as being spokeswoman for the Liberals in Legal Affairs Committee and rapporteur on this in the Internal Market and Consumer Protection Committee, and Maria Berger, Austrian Socialist spokeswoman for Legal Affairs. So you can see there's a broad support, and even the Greens, they are not so much involved. Monica Frassoni, as being the spokeswoman for Legal Affairs for the Greens, are supporting this. And the Communists, they are not very much interested in this, but even they vote in favor. So that's the way it is. So there is no problem on that point. Second aspect is, what are the opportunities of Parliament to complete it? I think the Commission, and the Commission is quite intelligent on that point, is taking a clear look on that, what Parliament thinks about it. That's logical. Because if this work is not done well, it's quite clear that Parliament will never support legislation coming out of it. That's clear. And from that point of view, the Commission wants to keep the Parliament in the boat. From all over the time, there was a strong cooperation between Commission and Parliament on this issue. And I think every step was done in discussion with each other, in agreement with each other. And I think the idea of the network, for example, originally came out of the Parliament. The idea of asking academics came out of the Parliament. The Commission has taken those ideas on board and has integrated them in their activities. So that's quite clear. And at the end, you must see what is the sense of the whole operation. The first sense, and that's guaranteed, it will be a toolbox. But a toolbox can only be used if you can use the tools. And the tools have to be used by the legislator at the end. And legislators are Parliament and Council. So that's the first point. Second point is, even on the question of the optional instrument. On the optional instrument, it can only become an optional instrument if the quality is high. And regarding the quality is high, there are two aspects important. First is, there is really a good legal quality in the way of better legislation, that this is good legislation. And the second point is that there is political approval regarding the content. So everyone who is dealing with this in the Commission has to take a look on Parliament and Council. Are they ready to support the political content of that, what is demanding there? For example, the question of the relation of B2B to B2C cases and other aspects play a big role in this. So I think we have all opportunities. And at the end, when we will write our report to the consultation on the CFR until the end of this legislation period, I'm very sure that the Commission will keep this in mind, because they know when they make a proposal later that if they do not make it the right way, we will change it in the legislative process. The system is very easy. The Commission makes a proposal, but Parliament and Council decide, not the Commission. They have the initiative monopoly, but legislators are Parliament and Council and not the Commission. It's a quite clear case. Second point is the relation between the results of the CFR and the Charta. The CFR is not a legal binding instrument. It's, as I said, a toolbox. Academics works. But the results of the CFR, that might be new horizontal or vertical directives or regulations. That might be the optional instrument, probably as a kind of a regulation. But this is secondary law. The Charter of Human Rights, I hope, will become prime law with the Constitution, or with the, I don't know how this development will happen. Nobody knows in this room. But I think there will be something. There will be another treaty post-Nizza. And this treaty post-Nizza, it doesn't matter how it is called, a treaty of I don't know where, or a constitution, or basic treaty, or anything like that, will have the Charter in it. I have no doubt about that, because I think there's a wide agreement between member states that the Charter should be in it. And then this is prime law. And from that point of view, I think the relation is clear. The Charter has the priority, and the other is just secondary law that has to be orientated its interpretation and the way how it is decided towards the principal rules of the Charter. That's quite clear. It cannot be against the Charter. That's logical. Okay.
Président Alpa.
Question or just to check if we share the main feelings.
is clear the position of the Parliament. It is clear the position of the Council. It is not so clear the position of the Commission, because the DG Sanco is doing this work on CFR net, but the DG Justice and Public Affairs thinks that the problems could be solved looking the choice of law rules. And the DG Competition thinks that it is better to put legal systems in competition between them. So I cannot understand if the work by the Commission is just a work to do something and to producing some result without reaching the last aim, the final aim, or if the hopes of the Parliament, and which are shared by many, many jurists, will in some way, will find some way the right solution.
I will try to give you a very, very frank answer. I don't know if someone from the Commission is here in the room. Probably he will not be extremely amused, but I have a personal clear opinion on the way how the whole thing is developing and where the problems in the Commission are. First, it is absolutely clear that everything in the process was supported by the Commission as a collective organ, quite clear. So I know that there are different opinions in some general directorates, and that even some commissioners are more interested and others less. But the Commission as a whole has introduced the whole process and is supporting this. And there are always different personal opinions, that's clear, but the general line of the Commission is determined. That's what my feeling is, and what clearly is the outcome of all the proposals we had seen, of all the decisions that had been made within the last time. Commissioner Byrne was very dedicated on this when he was in charge of this. You know, from his background, he was a general attorney in Ireland and supported this idea from the beginning. His successor, Commissioner Cipriano, to be as well clear, was less interested on this point. I'm trying to be careful in my words right now. We had meetings with him as rapporteurs and shadow rapporteurs, and my feeling, and as I've heard from the other colleagues, their feeling was that, to be careful, it was not really one of his priorities. The other problem is that we know that there are already some dissonances on the approach that has to be taken. You know, there are two units involved within the DG Sanco, and those two units, that's my personal feeling, they would deny it, that this is right, what I'm saying here. They are not always completely in line what they are doing. There are sometimes differences. This was another one, this is another problem. But both units are determined to the process. That's on the other side as well clear. If I take a look at the other DGs, DG Market, Alexander Schaub, who was the former general director until June of last year, was personally of the opinion that this whole project is a waste of time. That was his personal opinion. So the DG Market never supported it, never supported it. I tried to convince him the other way around, but it did not work. McCreevy, he has specific other interests from which he thinks that they are more important, and McCreevy, as Internal Market Commissioner, is someone who more follows the line, doing less is better. I agree with this, but doing nothing is worse. That's my personal comment on that point. So there is as well not too much support on that line. Commissioner Frattini is very much interested. When you speak with him about that, I think he's clearly of the position that this is something that belongs into the hands of the Justice Commissioner. It does not belong into the hands of someone who is doing market policy, or, as it is the simple fact, consumer protection policy in the first meaning. And the only problem that Frattini has, you know, he has a very, very small and very efficient general directorate, but they have a lot to do. They are doing all the internal policy, judicial cooperation aspects, immigration aspects, and things like that within the EU. And this very, very small DG is overloaded with work. And there's resistance in his cabinet and resistance in his GD in taking over this. They would be probably ready to take this over if they get the people, if they get the personnel. But then you see there are always the same competitive difficulties between one DG and the other, and to take a whole unit over that is not only doing this, but doing something additional, it's quite difficult. So I tried to use some of my influence that I have in some areas of the Commission to tell them that this is now a good chance when there is a move of competence in the direction of one or two new commissioners. It could be a chance to take out some aspects and to make some changes within the structure and giving this to Frattini. I don't know if this will happen. My feeling is it will not happen because Barroso is not ready for a shift. If he really is making a shift, there will be some other demands for shifts, and at the end he has to make a lot of shifts, and then he gets in conflict with Parliament simply because Parliament will say we want to be participants, we want to have wider hearings, and at the end we need a complete new approval of the Commission. There are some as well constitutional legal problems regarding the treaty on that point. So I'm more expecting that right now, with the beginning of next year, the new Bulgarian commissioner will take over the charge on this file as well as on the whole question of consumer protection. And what we probably have to do right now, and I'm trying to do that, just to concentrate her focus quite early on that subject, that she really sees the chances behind that and supports this politically. And I think there is a chance, because the advantage is she will be only in charge of this, consumer protection and the CFR, and not of health issues and other important questions that are connected to alcohol and smoking and other very popular discussion points in the political public. So I personally believe that there is a chance behind that, and we should simply try to use the chance to discuss it with her so that her focus falls on that subject. So that's the way it is regarding the actual situation within the Commission. General support, internal difficulties, but I hope that with the change of the competences, there's a good chance for a new approach, a new beginning in new thinking within the Commission.
Y a-t-il d'autres interventions, après qu'on ait compris effectivement les différentes compétitions entre les institutions? Pas d'autres interventions? Donc nous allons pouvoir passer au deuxième thème concernant les travaux académiques, donc manier des idées folles. Et je vais laisser immédiatement la parole, enfin la présidence, au président Alpha.
Thank you, Mr. President. The subject of my report should be the replies to the questionnaire, but when I received it, I thought it was better to reply in a more detailed way. So it was, the report was too much as a reply, a questionnaire, and too short for a real report. So it is something in the middle. I'll try to waste so only a few minutes just saying that one of the best results of this project is that it has been a great discussion for all the jurists coming from different countries, comparing their legal systems, comparing their legal terms, comparing their way of reasoning. And so, from a cultural point of view, it has been already a great success. We had, at the very beginning, different approaches. In some countries, the first reaction was negative, particularly because the word used was code. And, of course, those countries where codes were not introduced, were against even the idea of a code. The countries where codes were already existing, and particularly if they were a sort of a historical monument, like Code Napoleon, it seemed to be an insult to think to replace this historical monument with a new European code. But from the other side, many jurists thought, like in Italy, for example, that it was easier to write a code with the aid, with the help of all the European lawyers, instead of leaving things like they are now, that is to make a race between legal systems, or even to apply just the rules concerning international private law, that is the rules concerning the choice of law. Now we can see that the scenario, the cultural scenario, is much richer than before. And so in my report, which I will not read, of course, because I want to leave much more time to Professor Jubil, the subjects and the items which are discussed are extremely various and extremely interesting. I must say, really fascinating. For example, one of the supporter of the situation like it is Sir Roy Good, but in the field, not in the field of contract, but in the field of commercial law, he supported the codification of commercial law, also if he is a master of English law. In Italy, we have different positions. For example, the position of a great teacher, who is Natalino Irti, who wrote a book about nihilism, legal nihilism. He says that we cannot think to a European level while the world is going in different ways. Globalization from one side and localization for the other side. Other critics to the idea of a European civil code comes from the group, so-called the group of the Manifesto, which says that we cannot think to a European civil code as it were the byproduct of the so-called ordoliberalism. It means rules which are built in favor of the market instead of in favor of the protection of the social interests. Another critique is coming from so-called contractual justice, something that it is better to achieve a common principles in which the will of the parties can be corrected according to the general values, and others who think that any code could be a limitation of the freedom of contract, and for this reason they oppose any intervention, any legislative intervention coming from the European Commission. There is another critique, and Marco Bisogni told some words about this field. The connection between these rules and fundamental rights. I think this was one of the questions discussed by the Landau Commission, Landau Bill Commission, and also by the von Baer Commission. I don't know whether they have reached some result about this aspect. In any case, in Italy, we think that constitutional rules can be applied directly, like if it were a sort of Drittwirkung, to the private relationships. And so for that reason, we say that the code or a set of principles concerning contract law should take in account also the constitutional values. There is also the position of those who do some researches in the field of economic analysis of law. I thought before reading these essays that they were against the idea of common rules concerning contractual law, usually because we think that from an economic point of view, the competition between the legal systems should be better than common values shared by the contractual parties. But after having read these essays, I discovered that also those who look at this problem in the perspective of economic analysis of law think that at the end of the day, as it is difficult to calculate the costs of the codification, but you can calculate the benefits of the codification, at the end of the day, the codification is the best solution. There is another problem which has been raised by l'Onorevole Lehne, which is the level of harmonization. I think this is one of the most difficult questions, because our colleague Wilhelmsson says that in some countries the level of protection of weak interests could be higher, and after introducing a codification of contract law, this level should be reduced. So this could resolve in a worse situation of the citizens who benefit of a better position. Which is the position of the Italian government? I invited the two representatives of the government, but they could not reach us. I mean, I don't see them here among us. They were nominated, appointed by the former government. I don't know whether the government Prodi has changed his mind. We never knew which was the position of the Italian government. So the position of the Italian government was that expressed day by day by those who participated to the meetings organized by the community in this proceeding of CFR-net. I am not sure about the position of lawyers, but my hope is that having done so much work since 1999 in this field with the Italian Bar Council, I think they should appreciate this work. And just to reply to some of the questions of the questioners, the questioner, I think that they could react positively either to the application of these rules to consumer contracts and either to the application of this rule to B2B contracts. We don't have any fear of a code. We don't have any fear against any instrument like regulation or like a directive. Of course, if the result is just a model code or an optional text that the parties could choose, the problem is not solved completely because the weaker party should always be in the worst position. From an Italian point of view, I should say, rudely speaking, as the Italian language is not one of the most important languages in Europe. As the Italian language, unfortunately, is not studied or known abroad, as the Italian legal system is not well known, or it is known only in in Spain, in Portugal, and in southern America, we think that in our system, or in our perspective, should be better to have a European code instead of having a competition between legal system, or becoming a sort of one of an empire. And in this case should be the British Empire, because common law is one of the strongest legal system, is the strongest which is supported by the bank, the World Bank of Investments. And in some way we admire, of course, the English legal culture and the common law system, but would like also to race with the same forces, I mean with the same power, which is not, of course, in this very moment, in Italy particularly. So, for that reason, I think that, or I suppose that Italian lawyers should support the initiatives of the Parliament and the Commission, and will welcome any result of this process. Thank you. Why not? I don't know. Lei sa se c'è il caffè, se è possibile prendere il caffè? Va bene. She will tell us whether the coffee is ready. Because
I hate to keep people from their coffee.
Bene, allora sospendiamo. How many? A quarter of hour? Is okay? 15 minutes, okay? Thank you.
Maybe we resume the meeting and the conference for this afternoon session. And I'm most honored to now open the second theme, namely, so to speak, thanks. So to speak, that Professor Guido Alper is talking about the present state of work of the academics. He himself is an academic and a practitioner, so we are extremely interested to hear what he's going to say.
He has.
Oh, I'm sorry. That's why I'm late.
He didn't tell you.
I'm sorry. Now, Professor Beale, it's your turn.
Thank you. I've always wanted somebody to say that to me. Usually they say, not you again. Perhaps I could begin by thanking both the Ccbe and the Consiglio Nazionale Forense for the very kind invitation here today. It's a great pleasure and a great honor, and I'm very grateful to them both. What I would like to do, if I may, is to explain why I, as one of the academics, very dangerous, and obviously already under suspicion, think that actually the common frame of reference, or CFR, if I can call it that, is important and deserves the full support of the Ccbe. And as Mr. Lehner has explained, the project is, I think, at a point of crisis, and I'm very, very glad to hear that the project has such strong support from the Parliament. However, I'm going to present the project in a very slightly different way to Mr. Lehner, because he is going rather too fast for me. I am an academic, he is a politician. That's the natural order, that he goes faster than I. But let me explain. If you think back to the action plan on contract law, which was published by the Commission, it aimed, the CFR was to have two purposes. One was a very long-term purpose, possibly to be the basis of an optional instrument. But the first aim was to provide, and I quote, fundamental principles, definitions, and model rules that could assist in the improvement of the existing acquis communautaire. And you'll remember that parallel to this project, there is a review going on of 8 consumer directives. And the idea was that when the directives were revised, the common frame of reference would be used to help with drafting the new directives. Now, let me also just say something about the academic research, because Klaus-Heiner Lehner quite rightly pointed out that the Commission, on the advice of the Parliament, had decided to use academics rather than to bring in consultants. And the academics were encouraged to apply under the FP6 program, as you said, for money. And I think there is some misunderstanding of how that process works. It is not, as I understand it, I wasn't involved directly, but as I understand it, it is not the Commission asking people to tender for a particular job, like they would a consultant. FP6 is rather like a process of giving grants to academics. Academics put up the project, and FP6 decides whether to fund it or not. So, of course, the academics naturally would ask for as much as they could possibly get. And so they asked for money to do everything, and they were given money to do everything. And you can hardly expect them to give it back. So I think that is one of the explanations why the academic common frame of reference is so wide. And it is, of course, very wide indeed, because you'll remember that it covers not only general principles of contract law, consumer contracts, but it covers many special contracts, and it also covers things which have no direct connection to contract at all. Things like unjust enrichment, negotiorum gestio. I still haven't quite discovered what that is. It's translated as benevolent intervention, but in English I call it sticking your nose into somebody else's business.
Without permission?
Without permission. Without permission, but you get paid for it. Wonderful idea, yes. And even property law subjects. So the academic common frame of reference is very wide indeed. And meanwhile, of course, this study of the 8 directives has been put into place. That's being carried out by another group, though with some people, members of both groups, because the study is being done by a group run by Hans Schulte-Nolke, who many of you will know is also a prominent member of the network. And if I may just say one word about the stakeholders groups. Many of you know just as much about the stakeholders groups as I do, because you've been to as many of the workshops, or even more of the workshops than I have. But I would just like to say that for the most part, the academics, the researchers, very much welcome the stakeholders meetings. True, there are 1 or 2 who have said, are we going to get anything useful out of these meetings? But that was more the problem about the meetings not being very well organized. I think everybody feels that we must have practical input. And one of the acknowledged weaknesses of even the principles of European contract law, the Landau principles, was that many of them had never been subject to practical discussion, simply because we were always working for the Commission, or at least the Commission was trying to put pressure on us, and there wasn't time to do it. So this was a great opportunity for us. Now, you all know how the project has changed. And the first change was something which became evident very quickly, and that is that this academic common frame of reference was far wider than anything which would be used certainly as an optional instrument, but even as a toolbox. And this is where I want to draw a distinction, which perhaps Mr. Lehner didn't draw so clearly because he's perhaps not so worried about it, but it concerns me. I would distinguish between three elements. The academic common frame of reference, which is this very, very wide project. The common frame of reference as a legislative guide or toolbox, and ultimately the optional instrument. For me, the optional instrument is a long way in the future if it ever comes to pass. I am more interested at the moment in trying to produce what I call the toolbox, and I'll come back to that point in a moment. But you all know that we started with a GRIG project with lots of workshops scheduled. There were to be workshops on virtually all the topics contained within the academic common frame of reference. I think there were to be 30 workshops. And that's how we started off. But after the London conference and Commissioner Cipriano's intervention, the project was narrowed very much down. So that and for the benefit of the translators, I'm now moving to page 4 of my paper. We actually only had 6 workshops this year, dealing specifically with topics directly related to the consumer acquis: pre-contract information, cancellation rights, unfair terms, 2 on sales, and then 1 on consumers' rights to damages. Now, actually, those of you who were at the workshops, and I know some of you were, perhaps you'll agree with me that I thought they were really quite useful workshops. It's true that some of the material that had to be discussed was at a very preliminary stage. It had not yet been worked out in detail. That is because the researchers were being asked to do things very quickly. But actually, there was good discussion. The comments we received from the stakeholders were extremely useful, and the Commission officials joined in and seemed to find it very useful. But those were the Commission officials who are in the group responsible for revising the consumer acquis, and they were concentrating very much on that. Those 6 workshops ended in July, and the big question is, what happens now? And we don't know. Some of us hoped that we would get some indication from the Commission officials at the Vienna conference in May, but it didn't happen. But you have probably seen the announcement from Commissioner Cipriano, which I only saw actually after I had written this paper, saying that the future of the workshops is still undecided and it is not clear whether there will be any workshops, and I'm sure Mr. Lehner is right to say that they're very unlikely to be any more workshops until well into 2007. From our side, we were asked, what would you researchers like by way of workshops? And what we have indicated is that we want to have workshops to discuss the general principles of contract law, because many of those, as I will explain, are directly relevant to the common frame of reference as a toolbox. But in the 6 workshops we had, there simply was not time to discuss the general principles. It is true that we did present the material. If you look at the papers for those workshops, you might well think, well, actually, you did manage to discuss most of the general principles of contract law. That's because I insisted on giving stakeholders the relevant material as background material, and the Commission very kindly agreed after some hesitation. But we didn't have time to discuss it. So we have asked if we can have workshops on things like general provisions, formation of contracts, validity, and so on. And you'll find the list on page 5 of my papers. Now, I don't think, though, that I can ask the Ccbe to support the CFR without explaining why I think the CFR is so important. And this means thinking about why we need a CFR. What are its purposes? And I don't mean to criticize the Commission when I say that I think we have all been trying to work out as we go along what it is that actually the Commission wants, and that includes the Commission. I don't think they had a very clear idea of what they wanted, and we have gradually been trying to focus our efforts. But I would like to talk this afternoon simply about the purposes of the CFR as a legislator's toolbox. Remember that the action plan stated that the CFR would set out, first, common fundamental principles of contract law, including guidance on when exceptions to such fundamental principles could be required. Second, definitions of key concepts. And third, model rules, which the document said would form the bulk of the CFR. And the annex to the paper, I'm quoting from the paper called The Way Forward, which was published in 2004, suggested that the CFR should indeed cover most of the rules of general contract law. For example, most of those which are found in PECL or the Unit Droit principles, with the addition of rules for consumer contracts and also some specific topics, and they listed sales and insurance as examples. Now, I don't want to get into a long semantic debate about what is a definition, what is a model rule, etc. Because it seems to me that this division that the Commission used between principles, definitions, and model rules is really not about the form of the CFR, but about its possible functions as a toolbox. And I think it may be easiest if I try to explain them in reverse order. So I will start with model rules. Now, we know the Commission is reviewing these 8 directives and it may revise them. Part of the review is all about how the directives have been implemented in the different member states, and in particular to what extent the member states actually go beyond the directives using the minimum harmonization provisions, and whether that actually interferes with the goal of trying to eliminate internal market barriers, because obviously if some member states have much higher requirements than others, that may cause barriers. But the review is concerned with more than that. It's concerned with the coherence of the consumer acquis, and it's concerned with the substance of the consumer acquis. And it seemed to us that if the directives are to be revised, the Commission would find it useful to have model rules which it could use or could adapt to replace the existing articles of the various directives. For example, the CFR might contain model rules showing how the principles which underlie the various sectoral directives could be made of broader horizontal application. And the action plan also seemed to envisage that the consumer acquis might be strengthened. In other words, the proposed rules might go beyond the existing consumer acquis. They include what the CFR called the best solutions found in member states' legal orders. In other words, I think they're talking about what you find in those states that actually go beyond the minimum required by the directive. And of course, this is going to be something which is particularly important if we move from minimal harmonization to what is now called full harmonization. I called it maximal harmonization the other day and was told off very severely by the Commission. That is no longer the correct speech. Please note, Michael, for your talk tomorrow. Full harmonization. And I think that, well, Michael will talk about this tomorrow, but I think there is going to be a very big battle if the Commission does want to move to a process of full harmonization, because member states which have better than the minimum protection will not want to give it up, whereas those who have only the minimum will probably want to stick with the minimum. So we can expect some fun. So I think model rules are an obvious thing to give the Commission, and indeed that's what those 6 meetings this spring were really all about. The researchers were suggesting ways in which the consumer acquis might be revised by putting forward alternative rules to the ones that are found in the acquis at the moment. But what about definitions? Well, model rules simply aren't enough, and we all know what the problem is. The problem is that, inevitably, directives use terminology, refer to concepts which they do not define. The obvious example, it's now a hack example, is the Simona Leitner case about the meaning of damage in the Package Travel Directive. In some countries it includes non-pecuniary loss, in others it doesn't. What is the correct meaning to give it? And of course the ECJ held that it must be given an autonomous legal meaning. Now, it's too much to expect directives to define every term that they mean. If they did, the directives would be like small encyclopedias, and I don't think anybody would be very happy. But it seems to us that a directive which contained definitions of these terms would be extremely useful for questions of interpretation of that kind. National legislators who have to implement the directive could consult the CFR. What did Brussels mean? National courts that have to apply the directive, or in my country, apply regulations which simply repeat the word of the directive word for word, would be able to go back to the CFR to find out what might have been meant. And in particular, if the CFR contains not only definitions, but comparative notes explaining how the definitions which are used are the same as or different from what you find in the national laws, that I think will really help the national legislator and the national courts. And of course, the definitions would be even more valuable if they could be somehow adopted by the European institutions, preferably by some kind of interinstitutional agreement, as a guideline for legislative drafting. What I would love to see is an interinstitutional agreement which says when we are drafting new directives, you can assume that when we use a legal term like damage, we mean damage as defined in the common frame of reference, unless we say otherwise. So we're not legislating by drafting the common frame of reference, we're simply providing a common legal terminology for using in drafting directives. And personally, I think that that would be very, very valuable. And of course, that was, as I understand it, what was at the heart of the original action plan, the common frame of reference, providing definitions. Okay, so I've dealt with model rules and I've dealt with definitions. What about principles? Well, it's rather difficult to know what these mean. I think probably what they mean is really very general ideas, such as that the legislator should always start with a presumption of freedom of contract and should only qualify freedom of contract where there is a very clear case for doing so. But it may be that principles are also to include such general norms as the principle of good faith. That was certainly one which was listed. But as soon as we say that, I think we come to a problem. And indeed, we come to a further possible purpose of the common frame of reference, one which I think is much more contestable than the ones I've discussed so far. It's providing what I call essential background information. Let's just think about this question of good faith. If the common frame of reference is to include a general principle such as good faith, what is the common frame of reference actually telling the legislator? The principle of good faith does not exist in the laws of all member states. I hate to say it, we don't have it in the United Kingdom. I have a lot of friends who are clearly nervous whenever they're on English shores because they say they were not protected by the principle of good faith. One of them said she was even going to bring her pistol. I don't know whether she did. But we simply don't have this rule. And it's exactly the same in the other common law jurisdictions, and indeed it's partially true in some of the Scandinavian countries as well. We certainly have many particular rules which perform very much the same function. We have lots of rules which say, you must not do this. When on the continent, you wouldn't be allowed to do it, not because there was some special rule, but because of the principle of good faith. But we don't have the doctrine itself. So the legislator can't simply assume that whatever requirements it's going to impose in a new directive will be in addition to a requirement of good faith, or will be supplemented by a requirement of good faith, or will be interpreted in accordance with good faith. That may well be true in the continental countries, but not in England. We'll interpret it in bad faith. And so it's really a question of being a bit misleading. What we would have to do is to say to the legislator, we all have the functional equivalent of good faith, but you've got to look at the comparative notes, and you will see that if you want something like that in England, if you want to achieve a particular result in England, Ireland, Scotland, you have got to spell it out in the directive, because it isn't a common principle. So, in other words, the legislator needs to have accurate information in a readily accessible form about the different laws in the member states. European legislators need to know what is a problem in terms of national laws and what isn't a problem. Let me take another example. Let's suppose that they're drafting a new directive on pre-contractual information. Legislators will want to know, what do we have to cover in the directive? What can we leave out of it because it's covered adequately and reasonably harmoniously in the laws of the member states, so we don't need to bother with it? Well, you would need to know, wouldn't you, about general principles such as mistake, such as fraud. They don't appear in directives because actually we've all got rules on mistake and fraud. I have to say our rules are pretty different in some cases, particularly on mistake, but we've all got them, and therefore the legislator in the past has realized that we don't need to legislate on mistake and fraud. But providing that information to the legislator seems to me to be a very valuable possible function, providing when we're drafting the common frame of reference, we make it absolutely clear which rules are shared by all the member states and which ones aren't shared by all the member states. And that's why I think that the comparative notes are such a vital part of the common frame of reference as a legislator's toolbox. So in addition to the principles, definitions, and model rules, the common frame of reference could usefully contain what I term essential background material. This would group the information about the different laws under headings which the legislator would be familiar with. Now, it can be argued that you don't need this essential background information in the CFR itself. It could be in a separate document. It could be just in a published version of the big academic common frame of reference. But I accept that, but I would actually include in the common frame of reference at least all the general principles of contract law. And that's for a very simple reason. We never know exactly what terms, what concepts the legislator is going to want to use suddenly. Let me just give you one example. In English law, we have a rather obscure doctrine called the doctrine of undue influence. It's usually about husbands bullying their wives into agreeing to mortgage the family home to support the husband's business. I never thought we would need a European definition of undue influence, but suddenly I find the Unfair Commercial Practices Directive refers to undue influence and uses it in, I think, a rather different way. It would have been useful to have something there so that we would have known what we were talking about. So simply because we can never quite tell what's coming, I would at least include the general principles of contract law. Now, my big problem is that I have absolutely no idea whether DG Sanko still wants a legislator's toolbox of that kind. They have said they think that the work on the consumer acquis is over. The workshops on the consumer acquis are over. Now, that could mean one of two things. It could mean, quite simply, that they think, well, we've discussed the general principles of contract law because Hugh Beale insisted on putting all of that stuff into the papers, so everybody had a chance to discuss it. But that would be a complete misunderstanding of what actually happened at that workshops. I think you'll all agree with me, those of you who are there, that we never really got beyond the specific consumer rules. Alternatively, the interpretation is that actually all they're interested in is a very, very narrow revision of the consumer acquis. And that's what I'm scared of. Now, we need to just talk for a moment about timetable. I quite agree that the academic common frame of reference is going to take some time to produce. It's not going to be ready until the end of 2007. I think we will make that, but it'll be difficult. I won't pretend. It's not going to be ready early. But actually, you probably don't need the common frame of reference as a toolbox until a quite late stage. Because what we're really talking about here is taking the ideas about how to revise the consumer acquis, how to improve the directives, and then drafting it. And it's at the drafting stage that you really need this toolbox, so that you can think, do we need to define damage? Do we need to explain when a contract is concluded? No, that's in the common frame of reference. We won't need that until quite a late stage in the process, and by then, I think it will be ready. Now, I had also prepared a section on the optional instrument. I'm not going to talk about that because I think that's going to come back tomorrow, and having tried to answer a lot of Michael Patchett-Joyce's points this afternoon, we must leave him something, poor chap, to talk about tomorrow. So we can talk about the optional instrument tomorrow. I agree with Mr. Lehner, it would be very valuable, I think. And I think it would be particularly valuable for small and medium-sized enterprises, because they are the ones who are likely to be dealing with relatively low-value contracts, but which may have a significant legal risk. The fact that they're low value means that you can't afford to go off to Clifford Chance or whatever wonderful law firm you use and get advice about the other party's law, and likewise they can't get advice about your law. But the fact that there's a risk means that actually you do want to know what your legal rights are. So it seems to me that that's where the optional instrument would be useful in B2B contracts, not in the big things, not in the big contracts that the big London law firms ever deal with, not in the multi-million-pound jobs, because in a multi-million-pound contract, lawyers' fees just disappear, they're small. Peanuts in comparison. It's the smaller contracts. Whether it would be useful for consumers, I think that's a very difficult question. But it was very interesting. I went the other day to a meeting of the English stakeholders who are concerned with revision of Rome I. The consumer organizations, I think, were quite rightly saying, actually, consumers aren't that bothered about what legal system applies. It never occurs to them. They're much more worried about what language will I have to argue in, which court will I have to go to, will I have to come back to Italy in order to try to get this dress that I bought in the Via Condotti repaired, whatever it is. But it was very interesting. Businesses, small businesses, were worried because, of course, they are doing something thousands of times. So even if there's only a small risk on any one transaction, and the consumer is only interested in one transaction, the business is making thousands of those transactions. And what was particularly worrying for them was the notion that they thought that they might have to deal with any consumer on that consumer's national law when they were selling over the internet and would have no real way of knowing where the consumer was, and might have to deal with 25 different laws simply within the EU, 26 indeed, or 27. On the 1st of 28. 28, yeah. So it's really quite a problem for them, and I was surprised that it was those SMEs selling to consumers who were bothered. So I think it has a role there. So I hope that we will continue with the optional instrument. And then a last point. I think that there is a value quite beyond the common frame of reference as a toolbox or the common frame of reference as an optional instrument. And it's really, I think, the point that Guido Alper made earlier this afternoon. These efforts are gradually producing a common legal terminology that we can use to discuss things. Of course, we can translate from one language to another, but any of us, and I suspect most of us in this room, who have been involved in comparative law of one kind or another, whether it be academic or practical, know that translation is an extraordinarily difficult problem. And in particular, there is the problem of the false friend. That is the term which is used in both legal systems, and it takes us 2 years to realize that actually we're using it in completely different ways. And I've had this experience many times in the Lando Group. Even with lawyers as able as Professor Ulrich Drobnik, we've agreed a text. 2 years later, Ulrich gives me an example, tells me the answer. I say, no, Ulrich, you've got that completely wrong. And we discover that we've just understood it in completely different ways. I do think that we have an interest in making it easier for lawyers to talk to each other across national boundaries. And it seems to me that the bigger value of these projects is that there would be a semi-officially sanctioned lingua franca for lawyers. So, those are my reasons for asking the Ccbe to support us as strongly as the Parliament is supporting us, and I'm really grateful to the Parliament for their support. Thank you very much.
Thank you, Professor Beale, for your extremely interesting and demanding analysis of the present status of the European contract law process. The floor is yours, ladies and gentlemen. Who wants to take the lead? Well, I haven't heard Mr. Lehner's speech, but I just want to know whether he is in line with the political ideas behind Professor Beale's analysis, or whether this is not challenging enough.
I think there's just one slight difference, and that is on the idea of the interinstitutional agreement. Because as well, on that point, I have some differences with Mr. Staudenmayer, who expressed this idea to me and who tries to find some support. I have my doubts if it is possible to agree in an interinstitutional agreement on material aspects, because normally interinstitutional agreements are just dealing with procedurals. And so I have some, if it would be for the first time, and I'm not so sure if this is really possible, even a situation in which one parliament is binding probably another one in the future. Okay, we have something like that in relation to first reading and second readings, because there is no discontinuity principle within European legislation. But on the other side, the European Parliament is covering this problem informally adopting the results of first reading of the older parliaments in one of the first meetings after the elections. So we are covering this somehow. There I have still some difficulties, and I don't know how we can solve this problem in the constitutional way. So I would more prefer to have a regular legislative procedure. And I think there are, from my point of view, two possibilities. First is, and that would be the next step, that we have a strong discussion with a resolution going into material aspects on the CFR within this legislation periods, clearly giving a feeling for Commission and stakeholders what Parliament wants, even on certain contents that have a political background. B2B, B2C questions, for example, is just one example. And then waiting for a proposal for this optional instrument. I still think that this has to be done in the next legislation period. And then we can go into details on the optional instrument. And the rest should be left as it is. That's more or less my feeling. Interinstitutional agreement, as I said, will be difficult. But we may see. It's probably too early right now to make a final decision how we go on this point. But I have some doubts if the interinstitutional agreement is really a possible instrument to solve the problem that you have rightly mentioned.
If I may just say so, I'm certainly bow to your much greater knowledge. I just picked up this idea from Staudenmayer, and I am not a European lawyer of that kind, so I don't know. The only thing that I wonder if I could ask you is about the prospect for the optional instrument now that Article 3.2 has been dropped out of the proposal for the Rome Convention. Because if you remember, Article 3.2 would have allowed the parties to adopt a non-national system of law, like the principles of European contract law or the UNIDROIT or any approved community instrument. And first the last bit went, but now I understand the whole article has been dropped, which is a little bit sad, really.
That has not decided yet. We have a first reading in Parliament. We get the report of Mrs. Berger next week. And my feeling is that in Parliament there is no majority for dropping it out. And then I think at the end we will see if there will be a conciliation. And at the end we have two chambers that have to make the legislative decisions, Parliament and Council. And I think we want this. That's quite clear.
Did you understand it correctly? You want this Article 3.2? Okay. Professor Alper, please.
have appreciated so much the speech of Professor Bill. I think the CCBE shares his view about the criticism, how about the method used by the Commission in organizing the seminars. And what to me was shocking is a sort of mystery. Where will go or where is gone all the work which is done? Because I participate to some discussions in these meetings. We don't know the result of the meetings. Do they record the criticism or the result of the discussion? What they do about the result of the meetings? I don't know whether the researchers know something about the result of these meetings or not. Second, I am not sure that the action plan was, really productive in putting different options which are not per se options. For example, ameliorating the acquis. I think this is a need of any legislator. It has no connection with the creation of a common frame of rules. Ameliorating the acquis means that the directive should be put in a systematic order, and they could be considered a text which has to be cleared where the terms are obscure. But this is a job that could be done directly by the Parliament or by the Commission without putting up without building all this work. I share your views about the useful work of the CFR, but I ask to myself as a lawyer, should we leave, as the European Court of Justice says, that the remedies are an area left to the national judge, or in order to protect consumers in the same way and the same level, should not remedies in some way harmonized? For example, I give you a concrete example, a practical example about pre-contractual information. In Italy now, there are different replies. Someone says pre-contractual information means that if the professional does not give these informations in advance before signing the contract, this is a violation of a rule which we have in our code, which is taken from the German tradition, and which is liability in negotiation, culpa in contraendo. And the result is not a complete satisfaction of the party which has taken the damage, but just the payment of expenses. So a reduced satisfaction. But there is another interpretation which says, well, if the professional did not give the informations before signing the contract, this is a violation of a statutory law, and this means that the contract is void. We have another interpretation saying that it is not a question of voidness, but a question of breach of contract. So we have, this is, I don't think it is only an Italian problem, but if we knew what the directive wanted to say in this case, which kind of remedies, and why, consumers should have different remedies if they bring their action in England or in Italy or in France. This could be a good field for lawyers because they can have another plan where they can give the effort and the consultation and their advice. But in any case, for consumers, is not the best choice. I don't know what you think about, but actually the rule is that remedies are left to national legal systems. I think the only exception is the directive concerning distant contracts having for financial services, in which the lack of pre-contractual information leads to the voidness of contract. This is, I think, this is the only exception, but I wonder whether as it is an exception, whether it was wise to introduce this rule instead of leaving things like they were.
Thank you, Professor Alba. You want to answer directly? Yes, please. Thank you very much. Well, let me take the points in order. First of all, as to the outcomes of the workshops, I'm afraid I don't know either. Well, let me give you what I would call the official Commission position and then the researchers' position. The official Commission position is that the Commission is to produce minutes of or an account of the workshop afterwards, and 6 months after that is posted on the Ccbe website, the researchers have to give a response explaining what they have done in response to it, or if they haven't done anything, why they haven't done anything. For most of the meetings, we've never had minutes. They've just stopped coming. And we can only assume that that is because the Commission is really no longer interested. Some of them, the early ones, were done, but many of the later ones have just never appeared. But before stakeholders think, well, that was then a complete waste of time, let me tell you that, of course, the researchers took their own notes, usually much more detailed notes, in fact, than the Commission took. And those have been thought about very carefully. And actually, in many cases, we have worked very hard at what the stakeholders said and have made some quite significant changes. We haven't agreed with everything by any means, but actually those stakeholder comments were taken into account very seriously in most cases. It is all a little bit tricky because Mr. Lehner mentioned that actually some of the work of the study group of the on the European Civil Code is actually being published already. And sometimes that is being published completely separately from the common frame of reference. You might think, well, why are you doing that? Why don't you just wait and publish the whole thing? And the answer is because we're trying to look after our young researchers. The young researchers who were hired before the common frame of reference ever started had invested an enormous amount of time in doing doctorates, but doing this research work, and we felt we must get their work into print. So we're producing what we would have produced anyway, and then we'll produce something different for the common frame of reference. But even some of the volumes which are being produced as a study group actually have been influenced by comments from the stakeholders. I mean, I'm working on the sales volume at the moment, and there are some things we think, well, that's all about revision of the acquis, that will have to leave. But there's some really good points that were made, and we need to change our text. Secondly, the action plan, option 3, yes, it wasn't an option. I mean, you can tell it wasn't an option. Even the UK government managed to support option 3. You know. But remember that option 3 was linked with option 2. That is, that they thought in improving the acquis, you should use the toolbox. So you define damage, etc., etc. So they're not completely separate. As to remedies, well, I think it is a problem, actually, that remedies are left to national law because actually there are quite serious differences. Let me just give you another one, which may now be out of date, because forgive me, but I haven't done my homework on the recent Schuldrecht reforms in Germany in full. But until the Schuldrecht reforms, in Germany, if you were suing on the basis of a defect, you got price reduction or rescission, but you did not get damages. Whereas in England, you would get damages. And so there were really quite significant differences in the risks that a firm was taking if it sent defective goods. Now, that was one of the reasons why we actually had a workshop on consumer damages, because when we were doing the sales workshop, people were saying, well, should we just talk about price reduction or rescission, as we do at the moment, or should we actually say, and the consumer should always have a right to damages? So I think you've got a very strong point there. That is an area where possibly something needs to be done. And I think it needs to be looked at across the board. That's not to say that we necessarily change everything. In some cases, it may be fine to leave it. But in some cases, I think there are real differences between legal systems and possibly real gaps in consumer protection.
Thank you. Any further comments? Yes, please. The micro because of the interpreters.
Thank you so much. Hugh, as you know, I'm a mere practitioner in all of this, and therefore I was looking at how the CFR might apply in practice. And I was interested by the example of the Simon Leitner case, and it seemed when I looked at the reasoning of the European Court in that case that it was really fairly straightforward. It started off by saying, well, what is the directive, the package travel directive, designed to achieve? Well, it's designed to achieve consumer protection. What does one expect to find in consumer protection? Well, one expects importance of non-material damage to be compensated in that context. And armed with that analysis, which was really a fairly straightforward analysis, the European Court then said, well, Article 5 of the directive has to be interpreted in accordance with those basic building blocks. Then I sort of stood back and said, well, how is a CFR, whether it's in the form of the academic CFR or a practical CFR, going to assist what is really fairly straightforward legal analysis? And what I'd like is really your views as to how the CFR would apply in practice in that situation, because it didn't seem to me that it was an obvious case as to where a CFR would have additional help over and above the basic analysis that the European Court of Justice undertook in any event. And if the European Court of Justice was able to get there without the benefit of a CFR, how would the reasoning or the judgment have been different if it had a CFR to refer to and even rely upon?
Thank you. Well, Michael, I hate to disappoint you, but my answer is I don't want it to have to go to the ECJ. I agree that the analysis was not particularly difficult. It was fairly obvious, I think, really, to be truthful. But if there had been some form of legislative instrument, whatever it is, whether it be an interinstitutional agreement or something else, which actually said, when we use the word damage in a directive, we mean damage as calculated in the common frame of reference, unless the directive says otherwise, then nobody would have any doubt whatever, and you'd avoid the need for litigation. So it seems to me that that is an example. Okay, it's a rather simple example, but it is an example where the CFR could be useful, because it would simply avoid any doubt. Now, we can, I think of more sophisticated examples. Even in the consumer area, there can be problems, for example, about exactly when a contract is concluded, when an offer is revocable and not, because we have different rules in our different legal systems and so on, which can cause problems. And if you were simply to assume that the CFR were drafted along the lines of the directive was drafted along the lines of the CFR, unless provided otherwise, it seems to me that you would avoid a lot of these doubts. We might even, for example, have had a much better idea of what the Unfair Terms Directive means by substantive, to the detriment of the consumer contrary to the requirements of good faith, which may not have bothered you, but it certainly bothered me for months at a time. And, you know, I had to write up 50 pages in the Law Commission report explaining what it meant. If there had been some definition, I think we might have been a little bit further forward. So I grant you that many of these problems can be solved by courts relatively easily, but I don't want it to have to go to court. I want it to be eminently clear. And in particular, and I think this is perhaps one of the most important points, I want it to be clear, I want it to be sufficiently clear that it can be explained easily to consumer advisors, not to individual consumers. Most consumers are not going to understand legal points, but not legally qualified consumer advisors play an enormous role in my country, the Citizens Advice Bureau, and also to businesses. I want a business to be able to look up and say, well, what are our risks under this directive in easy, clear language? So it's all part of the better regulation theme, to my mind.
Please. Pardon me. Do you mind that?
Just one extremely short remark, because that might be an idea regarding solve the problem of the lack of interinstitutional agreement. We could solve maybe easily it in just having a recital in making a general reference to the in any kind of directive that is covering civil law or consumer protection law, just a recital making a reference to the CFR. That's probably enough. Enough for the courts, enough for the interpretation of all things the CFR, all problems the CFR is solving.
Sir, please go ahead.
Preferisco parlare in italiano per la paura di false friends, quindi volevo chiedere al professor Bill che cosa ne pensa di questo sdoppiamento tra CFR e revisione dell'acquis, in particolare della possibilità che a me sembra abbastanza concreta, per aver assistito a un seminario della DG Sanco con Eurocommerce che presentavano il lavoro sulla revisione dell'acquis, che appunto la revisione dell'acquis vada con dei tempi molto più veloci rispetto al CFR, cioè c'è effettivamente in Italia si parla di un proverbio chi viene prima dell'uovo o la gallina, no? Qui un po' sembrerebbe che però dovrebbe venire prima il CFR piuttosto che la revisione dell'acquis, perché una volta che si fa la revisione dell'acquis poi il CFR dovrebbe copiare sostanzialmente, dato che diciamo, il maggior campo di intervento sul diritto civile resta sempre quello dei consumatori, insomma, quindi su questo avrei delle perplessità. Mi sembra che questo sdoppiamento tra le due operazioni sia un po' un modo quasi di uccidere il CFR, insomma. Questa è la prima cosa che volevo chiederle. Poi la seconda invece se può spiegarmi meglio la sua posizione relativamente a una strada che passa attraverso la trasformazione in regolamenti comunitari dei regolamenti Roma 1, Roma 2, Roma 3, cioè se questa è una strada alternativa, in che misura lei pensa si possa combinare con quella del CFR.
Forgive me if my Italian is so rusty that I was listening to the translation, which was very good, and I think I have it. So, first of all, the relationship between the revision of the acquis and the Common Frame of Reference project. Well, it's true that the Commission is trying to press ahead with the revision of the consumer acquis very quickly. And so there is a danger that the Common Frame of Reference will be left behind, as it were. It won't be ready in time to help. However, my impression is that actually the Commission officials who are concerned with the revision of the consumer acquis understood and agreed that it would be useful to have this list of definitions at a later stage. They were very tactful because, of course, it was not their responsibility. And Mr. Abamonte, who you know, you remember he's a very careful, very diplomatic person. He didn't say anything out of line. But my reading of his body language was that actually, yes, he thought that we needed general principles and so on, which would help him at a later stage. First, they have to fix the policy. The policy in terms of, are we going to have big horizontal directives? Are we going to give consumers the right to damages and so on? That is what I think they want to do next year. But I imagine that the process of actually drafting the directives and getting them agreed will take considerably longer. And that's where I hope that the definitions of the Common Frame of Reference will come in. Now, of course, the model rules have already gone in. And one of the things that does worry me is that we had only 6 workshops. And each of them dealing with material which was relatively in a raw state. I mean, the Acquis group had only just begun its work on some of these topics, and so they were presenting things which they themselves said, we haven't thought this all the way through. And I hope that there will be further workshops or some forum in which something more precise can come out, whether it be a discussion of a revised Acquis group text, or whether it be a discussion of the draft coming out of Giuseppe Abamonte's team. Doesn't matter. But we will need stakeholder input at some stage to discuss it when it gets to a further level. But that's separate, I think, from the notion of general rules. I think the general rules could be used at a later stage. As to the question of whether Rome I provides an alternative pathway, well, it seems to me that effectively, if we are to have an optional instrument, we have to have something like Article 3.2 of the as proposed in the Rome I Convention. Otherwise, how is it to work? It cannot be, I think, well, I think this is true. I don't think it will work if it is merely an optional instrument in the sense that the unidroit principles or the principles of European contract law at the moment are an optional instrument. I mean, you can agree to have your contract governed by the unidroit principles, but that will not displace national law. You are still subject to some national law. Of course, much of that national law are what we would call default rules. They are not mandatory, and so you are effectively replacing quite a bit of, say, English law by the unidroit principles. But nonetheless, you are subject to the mandatory rules of English law. That's not enough. What we need is to have an optional instrument which would be a complete replacement for national law, so that if you opt into it, you opt into all of it. You can't pick and choose. And that would be absolutely critical if it were going to apply to consumer transactions. If I sell my goods over the internet under the European optional instrument for consumers, I can't say, except for all the bits that give you protection. I've got to take the whole thing. Just as if I sold it under Italian law, I would have to accept the Italian mandatory rules. So we need something like Article 3.2. But of course, it doesn't have to be yet. It could be a further revision, but I would be very sad if you don't manage.
Better wording. We must see.
Yeah.
To such an optional instrument.
Yeah. I mean, one of the big problems that it was raised about Article 3.2 in my country was that it didn't seem to be a closed list. It seemed that anything could qualify.
That's the only
and so people were saying, well, you know, what about the old Lex Mercatoria? What about the rules produced by the British Bankers Association, which just might not be terribly favourable to the customer? What about Sharia law? You know, all sorts of things. Whereas I had in mind a closed list, you know, only the unidroit principles and PECL and the optional instrument would qualify. So that sort of thing has to be sorted out as well.
Any further question? I would like just to ask the question, did I understand you correctly, Professor Beale, that you were mentioning the protection, the required or the desired protection for the small and medium enterprises only on the basis of an opt-in instrument and not, which I would rather prefer, on the basis of an opt-out instrument? I.e., that these rules will be applicable unless you disagree and derogate.
Thank you. That's an extremely interesting and difficult question.
Sorry, because our questionnaire of the CCB was exactly based on these lines, and there are quite a number of legal systems represented by those delegates from to the CCB who are in favor if something of a toolbox, or call it as you want, or even a European contract law, if it is desired and agreed upon, then to have it on the basis of an opt-out instrument.
It's a very, very difficult question, and I don't have a final view, Mr. Chairman, but I think my initial reaction is to say that we should start with an opt-in instrument, because there will be a period when we don't know how well it works. And I would hate for people to be taking a risk of not knowing exactly where they stand without having chosen that more or less deliberately. What I mean is that just as with the Vienna Convention, there are going to be problems of interpretation, inevitably. We will not make something which will answer every question. There are going to be problems about which matters are covered by the optional instrument and which are left to the national law. And some of these in the early stages will be difficult questions which will be expensive to resolve. And I don't think we should make people do that unless they have consciously chosen. So I think I would begin by making it an opt-in instrument. At a later stage, possibly, one could make it an opt-out instrument once it has shown to work and once it's become more accepted. But I must say I don't have any very strong view. My only concern about starting with an opt-in instrument is the difference between the Vienna Convention on Sales of 1980 and the old Uniform Law on International Sales of 1964. The Vienna Convention is opt-out, and it has been used. The ULIS was opt-in, and in my country, I don't think anybody ever used it. Nobody ever opted into it. But I think that was a rather different environment. But Mr. Lehner may well have views on this, and I'm sure he's thought about it more carefully than I have.
I think this is, at the end, I think to have an opt-out instrument could be the final target. But we are in a political process, and the political process is something that is going step by step. I remember when I was reporting for the first time in the second half of the 90s in the working group of my faction in the Bundestag. And there was a reaction in the way that the chairman there said, why have we built this beautiful Reichstag when we have nothing to decide anymore? So, taking away competence on legislation from the national level to the European level is a difficult political process, a very difficult political process. And that's one of the reasons why the Commission and Parliament had been very careful. We had been speeding up a little bit in our wording, but the Commission had been extremely careful in the last years in going on with this process. I think Staudenmayer and Byrne, they had all the time a clear target at the end. They had a feeling where they wanted to go. But you must see it has to go step by step and very, very careful. And from that point of view, I think to realize this politically at the end, we should start with the opt-in. And then when the opt-in is working and this whole thing shows that it is good and it's accepted by the parties, and the next step could be, okay, it's so good that we can have change the principle into an opt-out. Why not? I think that's probably much, much better. That's, for example, was one of the reasons why the Commission in their original communications were mentioning the options, even if they had not been really options. But sometimes you have to ask crazy questions to bring it into the right process. And that's exactly what happened. I think no one wanted option 1 at that time. Option 2 and 3 are more or less connected. Everyone was in favor of option 2 and 3. But the most interesting point was the reaction to option 4. Option 4, most of the stakeholders said, right now we don't think that there is a need to do this, but we should think about it. And in saying we should think about that, they opened the door. And that's exactly the political process that has to go on. And that's what we are doing here. And to open the process first is that we now say, okay, this is a toolbox. We use it as a toolbox. There is no discussion about that this makes sense. The next political step in the next legislation period is the optional instrument. And then we see how this will make progress, how it will be used. Then it might be at the end that we get something more general and more binding for cross-border cases. It might be. And let's see, but it's a step-by-step process, and I think because we have to be careful, it should be better that we have an opt-in the beginning, and then we see what we do with it later.
May I just make one small remark, which I might outline a little further tomorrow. My main concern is the following. We have, to the best of my knowledge already, a rather expanding Anglo-American contract practice within the capital market, within the big deals, within all those large contracts, name them. At the far end side of the consumer protection, we have mandatory rules almost all over the place. And I'm afraid of the squeeze, not only for the small and medium enterprises, but also for the somewhat larger enterprises, because they are lost. They are left to the national laws, because the national law plays a much larger role in these contracts than it plays in the large contracts governed by the Anglo-American contract practice. And consequently, in order to mitigate this squeeze, I would rather have an opt-out instrument, because no one will opt in unless he is forced to do so. That's my concern, and the experience also with the Hague Convention on Sales Law, which was the predecessor of the Vienna Convention, which had absolutely no cases during the time it was in force. So it's rather a political approach to help and to counter, if I may say so, the influence of the Anglo-American, I don't say law, but contract practice.
I think that's a very important point, Mr. Chairman. I think, though, that having an optional instrument, whether it be opt-in or opt-out, is actually only going to deal to a fairly limited extent with the problems that are faced by small businesses, particularly when they are dealing with larger businesses on the other side. And there is some sort of either inequality of bargaining power in the classic sense that I can dictate terms in the market because I'm a very big buyer and you are a small seller, or whether it's simply that we are not matched in sophistication, that you have lots of legal advisors and I'm just Hugh Beale and Company, a one-person company, and I don't have any legal knowledge. And the problem is quite simply, of course, that if the big company doesn't want the small company to be protected, it will opt out. And I mean, I have to say that in England, it's become de rigueur whenever the Law Commission gets some new act passed to protect people. For example, we passed a legislation conferring rights on third-party beneficiaries, which never existed in English law. We had the old doctrine of privity of contract. What happened? All the big law firms went to their computers and inserted into every contract in the book, the Contracts Act Rights of Third Parties 1999 does not apply to this contract. It was just done overnight. And of course, I think they would simply opt out. So I think that if we're really concerned about small businesses, and I know that your colleague Diana Wallace, for example, in her speech in Vienna, made a plea for protection of small businesses, I think that may actually have to be done by directives or regulations rather than by the opt-out. The an opt-out system would help, but I don't think it would do the trick entirely. So I think we may need to think about actual protection. And I have to say that in England, the government has now accepted the Law Commission's proposal to extend effectively the consumer directive to very small businesses. We're talking about micro businesses, people with less than 9 employees. But in principle, they have accepted it. Of course, that's not the same thing as implementing it, but at least it's a step in the right direction. And if the British will protect their small businesses, I suspect other people are interested in doing it too.
Just an additional argument, as well connected to the political process. The key argument behind the whole operation is that it is good for the internal market. The problem that you have mentioned is not mainly a problem of the internal market, it's more a cross-Atlantic problem. It's as well happening in the internal market, but from a political point of view, I think it's more felt like a transatlantic problem. And from that point of view, I believe it is easier when we speak about the internal market, that we say, okay, we have here an alternative for the businesses that they can use, that they have less duties, less problems within the internal market regarding legal advice and other aspects. And the other way around, when we speak about the pressure or the influence of the Anglo-American system, I have my doubts that this at the end will come through as a political argument.
I didn't say system, I said contract practice. Practice. That's an extremely different approach, I'm afraid. I'm maintaining the position that it is not the transatlantic, it's internal, because all the big players are using, Mark, you would say, templates based on the basis of the Anglo-American approach how to write a contract, and that's the point. Any other participant who wants to raise a question and to help us for better lawmaking? That doesn't seem to be the case, so it's the end, as far as I see it, on the program. And I do thank the participants who contributed to the discussion. I think it was very, very interesting, and I thank first of all and foremost Professor Hugh Beale to your presentation, who give actually the initiative to such a lively discussion, and I was really amazed how good it worked out for the CCBE, and tomorrow we'll go into the questionnaire and might come to a better understanding on all sides of the national systems. Thank you very much. Also on behalf of Professor Alper, I would say have a nice evening, and we're looking forward to see you tomorrow morning. Thanks a lot.